Stay with me, because what I'm about to walk you through looks small on the surface, almost trivial, but it carries consequences that are anything but. Late last night, inside a quiet federal docket that most people will never read, a judge changed one word. Not a paragraph, not a ruling headline, one word. And by sunrise, that single adjustment had collapsed the central pillar of Donald Trump's legal defense. This is how major cases actually turn. Not with shouting matches on cable news, not with dramatic press conferences, but with precise language written by judges who understand that words are levers. Pull the right one, and entire strategies fall apart. Here's the setup. Trump's defense team has been operating on a simple theory: delay, reframe, and elevate every dispute into a constitutional question. If they can keep cases stuck arguing over process, they avoid ever confronting facts. That approach depends on one critical assumption: that certain actions can be treated as official presidential conduct protected by immunity. For months, that assumption has been the oxygen keeping the defense alive. Then came the change. Buried in a procedural order, no press release, no television cameras, the judge replaced a single term that described Trump's conduct. The new wording reclassified what had been argued as official acts into something far more dangerous: private conduct undertaken outside presidential authority. That shift sounds technical. It isn't. In federal court, classification determines everything: what evidence is admissible, what defenses are allowed, and whether a case even survives the next motion. Why does this matter now? Because once conduct is labeled private, immunity defenses evaporate, appeals narrow, delays shrink, and prosecutors are no longer arguing uphill against constitutional theory, they're arguing straight facts to a jury. This wasn't accidental. Judges don't revise language casually, especially in cases of this magnitude. This was a deliberate signal sent quietly that the court sees the defense's core argument as unsustainable. What looks like a minor edit is actually a line in the sand. And once it's drawn, there's no rewriting history. To understand why this single word change is so devastating, you have to understand how presidential immunity actually works. Not the television version, but the version courts apply in real life. Immunity isn't a blanket shield. It's conditional. It protects actions taken in service of the office, not actions taken in service of the individual. That distinction is where Trump's defense has been living. For months, his legal team has argued that every contested act, phone calls, meetings, pressure campaigns, was part of his official duty as president. The goal was never to win on the facts. The goal was to keep the conversation stuck on status. Was he acting as president or as a private citizen? As long as that question remained unresolved, everything else stalled. The judge's revision quietly answered it. By redefining Trump's conduct as private, the court effectively shut the door on immunity-based delay tactics. That one word reroutes the entire case. Motions that once required lengthy constitutional analysis can now be dismissed in pages. Appeals that might have taken years lose their footing. What was once a high-altitude legal debate drops straight to ground level, where evidence, testimony, and intent matter more than theory. This is where experienced observers recognize the danger. When courts strip away abstraction, cases accelerate. Prosecutors stop negotiating with doctrine and start preparing witnesses. Judges stop entertaining hypotheticals and start scheduling dates. Defense teams lose the luxury of endless briefing and are forced to confront what they've been trying to avoid: 12 jurors sitting in a box deciding what actually happened. And make no mistake, this wasn't a typo. Judges choose words with surgical care, especially in politically sensitive cases. Changing how conduct is categorized signals how the court expects the rest of the litigation to proceed. It tells prosecutors they're on solid ground. It tells appellate courts what framework to apply. And it tells the defense, without saying it outright, that the runway is running out. What looks like semantics is, in reality, a structural collapse. Once immunity is off the table, the case stops being theoretical and starts becoming inevitable. What makes this moment especially damaging for Trump's legal team is not just the substance of the change, but the way it arrived. There was no warning shot, no dramatic hearing, no televised clash between lawyers and the bench. The shift happened quietly, through the one place defense teams often overlook when they're focused on the big picture: procedural language. Trump's lawyers were preparing for a familiar fight. They expected to argue over scope, how far presidential authority extends, where executive discretion ends, and whether courts should hesitate before second-guessing a former commander-in-chief. That's terrain they know how to navigate. It's abstract, slow-moving, and perfect for delay. What they didn't anticipate was the court refusing to play that game at all. By reframing the conduct as private, the judge sidestepped the philosophical debate entirely. Instead of asking, how much power does a president have? The court asked a much simpler question. Was this action part of governing, or was it something else? Once that question was answered, in the language of the order, the defense lost its preferred battlefield. This is a classic judicial move, and it's one that seasoned litigators recognize instantly. Courts don't always announce their conclusions with fireworks. Sometimes they let the words do the work. When that happens, the signal isn't for the public, it's for the lawyers. And Trump's team received it loud and clear. Behind the scenes, this kind of development forces a scramble. Strategies built around immunity suddenly look obsolete. Draft motions become useless overnight. Appeal outlines have to be rewritten. And perhaps most importantly, the psychological posture of the case shifts. Confidence gives way to contingency planning. The defense didn't miss this because they're inexperienced. They missed it because they were focused on stopping the train from the front, not realizing the tracks were being quietly switched underneath them. In federal court, that's often how cases are decided, not with noise, but with precision. Once that single word changed, the consequences didn't stop at immunity. It triggered a cascade, one legal door closing after another. And this is the part most casual observers miss. In complex federal cases, rulings don't exist in isolation. They interlock. When one assumption collapses, everything built on top of it starts to wobble. First, evidence. When conduct is framed as official, defense lawyers can argue that certain communications are protected by executive privilege, by deliberative process, by separation of powers. Reclassify that same conduct as private, and those protections weaken or disappear entirely. Text messages, emails, call logs, witness notes that were once contested suddenly become fair game. Prosecutors don't need to fight as hard to get them in front of a jury. Second, witnesses. Once immunity arguments lose force, witnesses who were previously shielded by ambiguity face a new reality. Cooperation becomes safer. Silence becomes riskier. People who were comfortable waiting out appeals start reassessing their exposure. That's when cracks form, not at the top, but in the middle. And in white-collar cases, middle-level cooperation is often what breaks the defense wide open. Third, timing. Courts tolerate delay when there's a genuine legal question unresolved. But when a judge signals that the core issue has already been decided, patience evaporates. Scheduling tightens. Deadlines harden. Judges move cases forward because, in their view, there's nothing left to wait for. For Trump's legal team, this is the nightmare scenario. Their entire approach depended on slowing everything down, pushing trials past elections, past political cycles, past moments of accountability. The procedural shift cuts directly against that strategy. It tells the court system, this case is ready to proceed. This is why seasoned analysts are paying attention, not because of the word itself, but because of what it unlocks. In law, momentum matters. And momentum just shifted decisively away from delay and toward resolution. It's important to understand that this moment isn't just about Donald Trump. Judges don't think in terms of personalities or headlines. They think in terms of precedent, institutional integrity, and control of their courtroom. And that's exactly why this one-word change carries so much weight. For years, federal judges have watched presidential power expand through custom and assumption rather than clear law. Norms filled the gaps. Courtesy replaced enforcement. The unspoken rule was that former presidents would never be treated like ordinary defendants because doing so might destabilize the system. But norms only work when everyone respects them. Once they're tested and ignored, judges are forced to respond. By reclassifying Trump's conduct as private, the court wasn't just narrowing his defense. It was reaffirming a boundary that had been slowly eroding, the line between governing and personal power. Judges are acutely aware that whatever framework they apply here won't stop with Trump. It will shape how future presidents behave, how future prosecutors act, and how future courts are expected to respond. This is why the language is careful, restrained, and precise. There's no moral grandstanding in the order, no emotional commentary, just classification. Courts prefer to discipline behavior indirectly, by defining categories that limit what defenses are even available. That's exactly what happened here. From a judicial perspective, this is also about restoring order. Cases bogged down in endless immunity arguments, clog dockets, and undermine public confidence. At some point, judges have to decide whether they're referees of an academic debate or arbiters of real disputes. This change signals a choice. Move forward. For an older audience that's lived through Watergate, Iran-Contra, and decades of institutional stress, this moment should feel familiar in one sense and alarming in another. Familiar because courts have stepped in before to restore limits. Alarming because it's happening only after those limits were pushed so far. Judges didn't seek this role, but once forced into it, they're making clear that the courtroom, not political theater, is where these questions will be settled. Here's where the stakes become truly personal for Trump. His legal team's strategy has always relied on time as a weapon. Delay everything. Tie the courts up in procedural knots. Elevate every motion into a constitutional debate. Keep the cases dragging past election cycles so politics, not facts, decide the outcome. But that one-word change destroys that foundation. Once conduct is classified as private, delay tactics lose credibility. Immunity motions, which were supposed to buy weeks or months, are now effectively moot. The defense can no longer lean on lofty constitutional theory to slow the process. The cases start to operate on real-world timelines, and federal judges don't tolerate unnecessary stalling, especially in high-stakes matters that touch the integrity of elections. The knock-on effect ripples across all jurisdictions. What happens in Washington, D.C. now influences filings in Georgia, Florida, and New York. Judges in those courts observe federal precedent closely. If immunity is rejected in one high-profile case, defense teams must recalibrate across all others. That's a cascading stress test, where a single procedural adjustment in one jurisdiction sends shockwaves through multiple legal fronts. The defense faces an almost impossible choice. Either mount new, narrower arguments within tight timeframes, or double down on appeals that may now seem frivolous in light of the reclassification. Meanwhile, prosecutors gain leverage. Witnesses become more willing to cooperate. Evidence that once faced procedural hurdles can now be admitted more easily. The playing field has shifted from theoretical to tactical, where facts and documentation dominate over clever legal framing. For the audience, the takeaway is clear. Trump's legal strategy, built over years and meticulously planned, now faces a structural collapse. One quiet judicial tweak has exposed vulnerabilities that were previously invisible, and the consequences will unfold over the coming weeks. The clock is ticking, and every moment matters. With immunity off the table, the momentum shifts decisively to the prosecutors. And make no mistake, this is not a minor advantage. In complex federal cases, control over evidence, witnesses, and timing determines the outcome far more than media soundbites ever will. And right now, the prosecutors are operating from a position of strength. First, witness cooperation is easier. People who once hesitated because of ambiguity now understand their legal risk is reduced if they speak. That means former aides, campaign officials, and even cabinet-level staff who were previously silent could now provide testimony that corroborates what the prosecutors already know. Each cooperative witness adds pressure on the next, creating a domino effect that can unravel a defense built on loyalty and delay. Second, evidence that might have been blocked as official conduct is now fully admissible. Emails, text messages, call logs, internal memoranda, documents that once faced procedural objections are now fair game. Prosecutors can present the narrative chronologically, letting jurors follow the facts without legal distractions. For a jury, clarity is everything, and that clarity now favors the prosecution. Timing is another critical advantage. Judges rarely tolerate frivolous or repetitive motions when a core immunity argument has been resolved. Trial schedules tighten, deadlines become fixed. Motions that once allowed for months of delay are now constrained to weeks or even days. That forces the defense to operate in reactive mode rather than proactive strategy. Finally, there's the psychological effect. Prosecutors know that Trump's team is scrambling to adapt to the new reality. Confidence cracks, predictable patterns break, and the prosecutors, methodical and disciplined, capitalize on every defensive misstep. In short, the courtroom is now tilted, and every strategic advantage Trump once had has been systematically neutralized. The result? The case accelerates. Witnesses cooperate. Evidence is exposed, and the defense is on the back foot. What looked like a single word is now a gateway to a cascading legal advantage, and prosecutors are moving with precision to exploit it. Here's where the story becomes truly personal for Trump. The prosecutors now have access to a witness list that reads like a who's who of his inner circle. Mike Pence, his own vice president. Mark Meadows, his chief of staff. Pat Cipollone, White House counsel. Cassidy Hutchinson, a key aide who witnessed critical events firsthand. These aren't abstract sources. These are people who were there, in the room, making decisions, hearing promises, witnessing threats. For decades, Trump relied on loyalty as a defensive shield. He assumed that people close to him would remain silent, that subpoenas and pressure would yield minimal cooperation. But with immunity off the table, that assumption collapses. Witnesses now have a clear legal incentive to testify accurately. Their risk diminishes, while their potential liability for obstruction increases. The calculus changes overnight. And the internal pressure isn't just legal, it's psychological. When mid-level aides start cooperating, it sends signals to higher-ups that silence may no longer be safe. This creates a ripple effect. people at the top begin reassessing strategies, wondering who else might flip, who might provide testimony that undermines carefully constructed defenses. The result is a destabilized inner circle. Trump's communications, once shielded by privilege arguments, can now be scrutinized. Every phone record, text message, or email becomes a potential smoking gun. And for an audience watching this unfold, it's a moment of suspense because the narrative is no longer abstract law. It's betrayal, loyalty, and exposure, all converging in real time inside the former president's own operation. As the legal machinery tightens, the stakes extend far beyond Trump himself. Federal authorities are acutely aware of the potential for unrest. Weeks of false election claims, amplified rhetoric, and public threats have taught law enforcement to treat statements from a former president seriously. FBI threat assessments have been elevated. Joint terrorism task forces are monitoring extremist chatter online. U.S. Marshals are preparing enhanced courtroom security for witnesses and judges. Barriers are being erected around courthouses. This is more than political posturing. It's a calculated response to history. January 6th demonstrated how rhetoric can ignite action. Now, every statement, every social media post, every public rally is under scrutiny. Threats are logged, time-stamped, and preserved as potential evidence of obstruction or witness intimidation. Each act, each word contributes to a growing legal record. The international dimension is also impossible to ignore. Allies and adversaries alike are watching. America's political instability sends ripples through global markets, NATO planning, and foreign diplomacy. If the U.S. appears incapable of holding its former president accountable, it signals vulnerability. From Beijing to Moscow, the perception of weakness emboldens rivals and reshapes strategic calculations. In short, the legal battle is no longer confined to the courtroom. It intersects with national security, public order, and international credibility. And for an older audience concerned with the stability of institutions, this is not abstract fear, it's tangible, real-world risk that underscores why these legal proceedings are unprecedented. Now, everything converges on a single, inescapable reality. The clock is ticking. The D.C. Circuit's decision has set a legal momentum that is relentless. 28 days until the full opinion is released. 45 days until trial motions must be finalized. 70 days until the Speedy Trial Act triggers formal deadlines. The defense has no room to maneuver, and every procedural option has narrowed. Trump's legal team faces mounting pressure from multiple angles. Witnesses are reviewing evidence. Prosecutors are strategizing with precision. Judges are signaling that delays will not be tolerated. Every filing, every motion, every statement made by the former president is being scrutinized in real time, creating a feedback loop where words themselves become evidence. Simultaneously, state-level cases in Georgia, Florida, and New York are advancing independently. Each has separate evidence, separate statutes, and separate deadlines. What happens in one jurisdiction informs but does not dictate outcomes in the others. That makes Trump's overall legal exposure unprecedented, and it amplifies pressure on his political operation. Campaign planning, voter outreach, fundraising, all are vulnerable to disruption by concurrent criminal proceedings. For the audience, the takeaway is stark. This isn't speculation. This is process in motion. The next 10 weeks will determine not only whether Trump faces conviction, but how the balance of presidential accountability is understood in the United States. What unfolds now will shape political strategy, legal precedent, and institutional trust for decades to come. The procedural collapse triggered by a single word has set off a chain reaction. And while media coverage may focus on rhetoric, The real story, unfolding in courtrooms, grand juries, and legal filings, is a quiet, methodical dismantling of a defense once thought untouchable.